Yes.
This is the first time I've been back to the Judiciary Committee in some time. I retired as Director of Common Cause in 2006, and have since then been writing a book. I spent 18 years here and was involved in the passage of 5 constitutional amendments. And so I recognize why this is a difficult thing that you undertake to get this right. I want to strongly urge that you support something close to the legislation that Senator O'Neill has proposed and that Senator Lenahan proposed before him. It's close to right, and it has the value of spare, simple, clean language. And unfortunately, this has gotten clogged up in the meantime. And I want to give one example, and then I want to talk about the reputation of the body, which I think is really what this is about. In 1988, my first job at Common Cause was to write an ethics complaint against Governor Ed Dupree. At that time, the law required that ethics complaints be kept confidential. Our board adopted supported that complaint, and people signed the complaint and had their signatures notarized with the knowledge that if they spoke to anybody about it, they could be subject to a $10,000 fine. The trial for the governor occurred behind closed doors, and it took 3 years to get there. It was only in 1992 that we finally opened the proceedings of the Ethics Commission that had been closed by law to the public. And that was the right thing to do. Now, there have been several questions raised today about appeal. Governor Dupree appealed immediately to Superior Court. He had been found in violation on 2 matters. I don't think we want to go into all the details. But the point was it went to Judge Pederzani. Judge Pederzani found that the commission had ruled correctly. He went through the transcript, the trial record, and discerned that Governor Dupree had been correctly found in violation. At several points during the adjudication, and I was there as the complainant, Governor Dupree said, "We got to get this over more quickly. This is taking too long. I'm being considered for a position in the Bush administration, H.W. Bush, in Washington, and this cloud is hanging over my head. I want to go forward." And there are some 2 chapters in the book that describe that proceeding, which have never been written anywhere. In its wisdom, the Ethics Commission, 5 of the 6 people who sat on the adjudicative panel had been appointed by Governor Dupree, including a friend of his for 30 years and a client of his, whom we had thought of challenging. In the end, they were unanimous that Governor Dupree had violated the law. And so it went to Superior Court, and as I've said, Judge Pederzani held it up to go forward. It went to the Supreme Court. The Supreme Court upheld 1 count and overturned another. And they overturned the second one because although they recognized that the governor had steered a state contract to a large campaign contributor, nonetheless, there was no quid pro quo. There had been no agreement between the governor and the campaign contributor. I disagreed with that ruling, but that's what the Supreme Court said. So what I'm saying to you is that the appeals process works. It's a sound process. Now, I want to go back, and what I really wanted to say to you today is to talk about why the Ethics Commission is important. When the Constitutional Convention came together in 1986, when those people were elected in November of 1985, Rhode Island was rife with scandal. The state housing agency, RIMFAC, was in the midst of complicated scandals, but had to do with houses and mortgages and cut rate things going to insiders. The Chief Justice of the Rhode Island Supreme Court was under the threat of impeachment. And so people were elected to that convention with the idea, with the promise to their voters that they would work on ethics. And they went forward and they created a strong ethics commission, and they said all public officials must be subject to the jurisdiction of the Ethics Commission. And the people approved that. Now, you can't get away from that. That's what the people approved. And they were very careful about that. It's interesting, when this case got from Irons to the Supreme Court, the Supreme Court, I think, made a flawed decision, and here's why it's flawed. The Supreme Court, 3 justices, said the Ethics Amendment and speech and debate were adopted by the voters the same day, November 4th, 1986. That was technically true. But in fact, the voters had no idea that speech and debate was on the, anywhere in the mix. The booklets that went out said very clearly, we are renumbering and making gender neutral the language of the Constitution, but we are not changing the intent of any section. But there was no mention in the minutes of the convention, no mention in more than 600 articles that the Providence Journal printed of speech and debate. There was lots of mention, lots of discussion about the Ethics Commission. The people knew that they were pushing for a strong Ethics Commission that would have jurisdiction over all public officials in the state. What the decision of the 3 justices in the Supreme Court did in Irons was essentially to say 113 members of the General Assembly are immune to prosecution by the Ethics Commission. That's what they did. Justice Sutel, who was not Chief Justice at that time, correctly said, it's our responsibility as justices, to discern the intent of the framers, and the framers clearly had the intent of saying, we must get the fox away from the chickens. And that appeared several times, and by fox, they meant General Assembly. There's no question about that. Read the record yourselves. Now, I want to go to, I want to say a couple other things first. At the same time, Senator Metz rightly asked the question about the reputation of the General Assembly. At the same time as the Constitutional Convention was meeting in the spring of 1986, the General Assembly was doing a couple things that were secret and deserved to be mentioned, and I want to mention them briefly. One of them was that there had been a confidential report commissioned by the Attorney General, Arlene Violet, about RISDIC, the Rhode Island Shared Deposit Indemnity Corporation. That report by a retired banker, Robert Stitt, and Charles Black, essentially said this is a house of cards and it's going to fall. It's overextended, there are insider conflicts of interest, it's a mess. The head of the Rhode Island Credit Union League was a representative named Bob Bianchini from Cranston. He was also the vice chair of the House Finance Committee. Legislation had been proposed to require that all RISDIC institutions get federal credit union insurance. It was proposed in both the House and the Senate. It was killed in both the House and the Senate. And part of the reason it was killed, and I don't want to go into all the details, what I think I want to do is I want to present to you the last phase, after the RISDIC collapse, when hundreds of thousands of Rhode Islanders were cut off from their mortgages and their checking accounts and their saving accounts. And people were coming here and they were kicking these doors and they were screaming, they were all crooks. That was what they were saying. And they were wrong, because not everybody was crooks. But unfortunately, some people with some profound conflicts of interest, again and again, were carrying the day. Now, what I've got here for you, and perhaps the clerk can give this out, is from the RISDIC Commission's report. The 4th section was called the General Assembly, a historic treatment of RISDIC and its insured institutions, and they talked about the manifest conflicts of interest in the General Assembly that protected RISDIC not only in 1986, but in the years that followed. And it says, listen to this. This is from, and Jeff Tights, who was the chair of the House Judiciary Committee, was the chair of this commission. So he knew what he was saying, what they were saying. RISDIC was created by an act of the General Assembly in 1969 by virtue of its close association with several powerful legislators. RISDIC received favored treatment throughout its 21-year history. Bills which expanded RISDIC's authority or which it favored for other reasons appear to have passed without debate. Legislation which attempted to impose additional controls on RISDIC or its members usually failed, even those where there was strong support from DBR. The point I'm making to you is the General Assembly stuck up for the wrong guys, and there were many conflicts of interest, and the conflicts of interest involved Bob Bianchini, they involved Senator John Correa, who helped to kill the bill on the Senate side. And that, by killing that legislation, the General Assembly brought the state of Rhode Island into a condition of terrible collapse that angered people as nothing had since who knows when. So what I'm saying to you is there were profound conflicts of interest in the General Assembly, but the Constitutional Convention delegates didn't even know about this one particular one that was crucial. I want to mention one more, and then perhaps you'll answer the questions. Another set of questions that were going on during the 1980s was that members of the General Assembly were creating for themselves special pensions. And some members of the General Assembly had unique powers. They were a senator named John Orbona, which some of you may know. He was a lobbyist until recently. He sat on the Joint Committee on Retirement, and he sat on the retirement board that administered the retirement system. And that was specifically legal. And over a number of years, Senator Orbona tweaked a little law here, tweaked a little law there, and these laws were then put before the General Assembly, often as part of the consent calendar, on the last night of the session, and so they stuck through without any analysis. And one thing after another changed the conditions of pensions, whether it was the transfer of credits, whether it was changing eligibility requirements. So what I've got for you here is the story, first about John Orbona. In 1995, he retired at the age of 52. He claimed 79 years of pension credit and $106,000 a year of pensions. And the General Assembly didn't and had not done anything about that. Year after year, he sat on that committee, and on the very last page of this document that I've given you, we've listed from the Rhode Island manuals who sat on that committee throughout the entire 1980s, from 1983 to 1992, and John Orbona sat on them all the time. So instead of protecting the public interest and watching out for the best interest of taxpayers, he was taking care of himself. He betrayed his colleagues.
Excuse me, Mr.
And that was
Senator
wrong.
Archambault.
Well, just to interject for a second, I don't think we have copies.
I've got them right here. I'm going to the clerk will pass them out. And you're welcome to read them. It describes the way, Senator, it describes the way Senator Orbona did this. There's a list of the specific public laws where he sponsored or was involved. I probably said
Lombardi.
Phil, but aren't we agreeing on the issue? I think that we are asking for the restoration of the Ethics Commission, restoring the jurisdiction of the Ethics Commission, so that those kinds of egregious activities will be unearthed by the Ethics Commission. I don't think there's anyone here that is suggesting that we cast that kind of behavior aside. I think you've heard, and I should say, back to John Marion, now you've heard 5 of us all say the same thing, that we're calling for jurisdiction of the Ethics Commission. However, I think that to use Senator G's comment, we have to get out of that rut, or as this young lady just said, we have to reach a compromise, and you were at the edge of your seat, and reach a compromise on the language regarding your procedural hurdles that we've been discussing. So I don't see, this is all wonderful history, it's wonderful information, but these are the kinds of stories that none of us want to be part of, and we fully support somebody to watch some body, DODY, to watch over that. And so I agree with you. And I think that behavior such as this is reprehensible. And so I think we're arguing the same point, respectively.
Well, Senator, I don't want to be argumentative.
Please don't.
But I think everyone in this room and everyone in this state needs to recognize that there is a profound difference here between those of you who are affirming that you want to bring the General Assembly back under the Ethics Commission and the citizens groups that have, with one voice, said to you, and I'm not speaking for Common Cause, I don't have a lobbyist badge, I'm speaking as a private citizen. But the people seem to have a different view. And I would simply say to you that the will of the people, what simply in 1986, was to say we want to get the fox away from the chickens. And therefore the legislature needs to get itself back and move something that will do that. Now I want to propose to you that the amendment as it went out last year from this committee, with the de novo trial provision for any public official in the state, would severely damage the process of the Ethics Commission. I say that from having been in the position of a complainant and watched the case against Governor Ed Dupree take 3 years from the time that we filed the complaint till the time he was finally found in violation and fined $30,000. That was a long time, and to say, all right, now we'll start again with the de novo trial, I've got another answer for you. And the answer is there's a simple way to fix this without the de novo trial provision. And if you would look on the first page of the bill,
which bill?
0056, Senator O'Neill's bill, in line 14, I'm sorry, thank you for asking. On line 14, you can you can get rid of the de novo trial provision. I mean, think about it. Many of you are lawyers. We don't have many jury trials. Most times people plead out. We have very few jury trials, but we couldn't give everybody a jury trial.
I have to interrupt, and going back to what Senator Collins, it's that one person that wants that jury trial that makes it so sacrosanct. And so, respectfully, I mean, the process by the Administrative Procedures Act versus the right to a trial by jury are two very distinct adjudications, and we know that.
Again, without being argumentative, Senator, the Ethics Commission process is set up by the legislature. The legislature controls the budget of the Ethics Commission. And Jason Grammett may speak after I do about some of that. But I would simply say to you that the people have said that we want to carve out a narrow exception here. Justice Sutel favored that narrow exception, simply to say that in this narrow area of conflicts of interest, you are not entitled to a jury trial. And the people have the right to say that. That's not the General Assembly saying it. The people, and here's how you can do it. In line 14 of Senator O'Neill's bill, after the second word where it says, subject to the jurisdiction of the Ethics Commission, add one simple phrase, notwithstanding the jury trial provisions of Article 1, Sections 10 and Section 15, the Ethics Commission shall have jurisdiction. So you can simply say, and then you let the people decide. You let the people decide. The people can say, we don't think that every General Assembly member and every public official across the state should be entitled to a de novo trial. I think that de novo trial provision, which I will say as someone who has probably been in more Ethics Commission meetings than even Senator Connolly. No, I think I have over the years. A jury trial provision for any person will have the effect of clogging the process so hopelessly and stretching it out for 6 or 8 or 10 years. I'm not saying this is absolute. This is a measured thing, but I'm saying there's another way to skin this cat. You don't have to do it by creating a de novo trial provision for every public official in the state. Instead, you can say, ask the people for a narrow exception to the jury trial provision for the Ethics Commission, which the people have embraced and supported. You can do that. And the people then can say, no, we think the jury trial is what we absolutely want. Or the people may say, no, we think that everybody needs to be under the Ethics Commission. Notwithstanding those Article 1, Section 10 and Article 1, Section 15. You can do that, and you can let the people decide, and that's what I asked you to do.